Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This time we are going to discuss the vicarious liability. A case law, good case law. Of course, this is delivered by Punjab and Haryana High Court, 2 judges bench. Normally, we know in the law of torts, vicarious liability means liability of one person for the act done by the other due to some relationship. You must remember the so-called legal concept or legal theory behind it or legal maxim also. Qui facit per alium facit per se. Qui facit per alium facit per se. He who does the work through another is deemed to have done the work by himself. Or respondent superior, let the owner pay. Let the respondent is the superior person because the owner will have the deepest pockets. So liability, the relationship is like owner and principal agent, then partner and master servant, like that. So now the case is whether owner of a vehicle is vicariously liable to pay the fine for the goods supplied by the owner of the goods. If you know the case facts, it will be easy for you to understand. So now, Punjab and Haryana, 2 judges, that is T. Ajay Tiwari and Pankaj Jain, while disposing the case of Vijay Manson, I don't know how to pronounce it, Managain, it was written like that. Vijay Manson versus State of Haryana in CWP 1564 by 2022 held that the owner of the vehicle is not vicariously liable for the owner of the goods for his default. Both of them are separate entities. If the owner of the vehicle and the owner of the goods are one and the same, definitely he is vicariously liable. He is liable, that's all. But here the point is owner of the vehicle is one person and owner of the goods is another person. Both of them should not be clubbed. It's not that easy to say. How? So now you go to the facts of the case. Right. Please remember, on one day, the goods which were being carried on in the vehicle of the appellant, that is, what is his name? Vijay Manson. It was, the vehicle truck was seized by the tax authorities, GST. Previously, we used to call them commercial tax people. Now they should be called as GST people. Yes, they stopped it, they checked it, and there were no proper bills for the goods which were being carried on in the vehicle. They stopped the vehicle, they detained the vehicle, they have imposed a fine, they sent notice under section 180 of the GST to the owner of the goods as well as to the owner of the conveyance, that is the truck. So the owner of the goods failed to comply with the notice. He did not at all bother. He did not come to the GST authorities. He did not pay any fine. He did not at all come. Owner of the vehicle came. So till 14 days, the owner of the goods, he did not come. They are not contraband goods. Please remember, they are the goods for which the bill was not there or the tax was not paid. So for that the vehicle was seized. Now the point is, when the owner of the vehicle approached and he is ready to pay the fine which is imposed to the vehicle, but he was asked as per section 129, please remember, as per section 129 of the GST Act, they say that the entire fine related to the vehicle as well as related to the goods has to be filed. Then only the vehicle can be released, otherwise the vehicle will be kept there. Now he has approached the High Court. What is this? There is no vicarious liability between me and that owner. I do not have any relationship. The only thing, the contractual liability. I have taken his load. I am taking it to so and so place. But in the meanwhile, the GST authority stopped it. We stopped it. So they have impounded the same. Let them impound the same. Let them release my vehicle. I am ready to furnish the surety. I am ready to pay a fine allotted to this. This is his argument. But GST authority says, section 129 of the GST, it says goods and vehicle can be released on payment of tax only. So please remember, now the High Court held that, Arey Baba, the owner of the vehicle is a different entity. The owner of goods is a different entity. So when the owner of the vehicle comes and he is ready to pay the fine relating to the fine imposed to the vehicle, definitely why didn't release it? There is no vicarious liability. So this man had no knowledge about the contents of the goods. So they are different entities. Owner of the conveyance is different from owner of the goods. So owner of the vehicle cannot be vicariously held liable. Owner cannot be forced to pay the fine for which he is not hired on the goods. So definitely the High Court ordered the vehicle to be released. Very good judgment. Please read it sometimes. So issues will be so tricky. అయ్యా మీకు అర్థమవుతుంది, ఓనర్ ఒకడు, బండి యొక్క ఓనర్ ఒకడు, సామాన్ ఒకటిది. సామానుడేమో సైలెంట్గా మాట్లాడకుండా ఉన్నాడు. ఓనర్ ఎన్నాళ్ళు పెట్టుకుంటాడు బండి అక్కడ? అయ్యా నాకు ఇంపోజ్ చేసిన ఫైన్ నేను కడతాను, నా బండి వదిలేయండి. కాదు కాదు, మొత్తం కడితేనే వదులుతామన్నారు. సో ఫైనల్లీ టు కంక్లూడ్, సో there is no vicarious liability between these things. Punjab and High Court has clearly stated that release the vehicle. That's all. Very good judgment. Read it if you find time. I have found it in live law. Right. Thank you very much.